Good morning, afternoon, evening, and welcome to Concerned Citizens Presents, a new offering on Village TV. Concerned Citizens of Laguna Woods is an organization committed to peace, social justice, economic equality, and a clean environment. For the duration of the lockdown, instead of its usual 2 meetings a month, Concerned Citizens will broadcast 2 programs a month on this channel. Our programs will feature films, lectures, and debates on topics related to our mission. We hope you enjoy today's program.
Welcome to Concerned Citizens Presents. My name is Suzanne Modell, and I chair the committee responsible for these broadcasts. Today, Concerned Citizens is grateful that COVID has again shut our meetings down. Why? Because returning to remote programming gives us the opportunity to hear from one of our most beloved speakers. Erwin Chemerinsky was born and raised in Chicago. He holds a BA from Northwestern and a JD from Harvard. In 1980, he began teaching law and soon became a national expert on the Supreme Court. In 2008, he arrived in Irvine to serve as dean of the newly established UCI Law School. In that same year, Dean Chemerinsky gave his first lecture to concerned citizens of Laguna Woods. The title, Beyond the Spin, the Election's Impact on the Supreme Court. For a decade, he returned annually to address us. Then in 2018, he moved away, taking up his current post, Dean of the UC Berkeley Law School. Mr. Chemerinsky is a fellow of the American Academy of Arts and Sciences and president-elect of the Association of American Law Schools. I was not able to count the number of books Dean Chemerinsky has authored or co-authored. Though many are texts for law students, some are for educated lay people. For instance, The Conservative Assault on the Constitution, We the People, The Religion Clauses, and most recently, Beyond Imagination, The January 6th Insurrection. The book he's going to talk about today, Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights, is a magnificent read. Published in 2021, it is written in ordinary language. It is organized in a clear chronological fashion. It uses real-life examples. If you, like me, are a political junkie with a commitment to racial justice, you must read this book. I thought I knew a lot about police misconduct. Actually, I do. Last February on this program, I interviewed a retired African-American police detective. We discussed several policies that were designed to reduce human rights abuses, more non-white police officers, sensitivity training, body cameras, civilian review boards, and federal consent decrees. I wanted to know why, in the long term, none of these policies has worked. This book told me why. So, without further ado, I turn our camera over to Dean Chemerinsky, who will devote about a half hour to summarizing the disquieting foundings in his book, after which a small group of concerned citizens will pose questions. Dean Chemerinsky.
Thank you so much for that very kind introduction and the very kind words about my book. It was always such a pleasure getting to speak to concerned citizens in person at Laguna Woods. I'm glad at least there's the opportunity to do it now by Zoom. The death of George Floyd focused national attention on policing. The reality is there is a serious problem in this country with regard to race and policing. The statistics confirm this. Early in the book, I present some of these statistics, and they're stunning. In 2016, Black males between 15 and 34 were 9 times more likely than other Americans to be killed by law enforcement officers. They were killed at 4 times the rate of young white men. Hispanic men are nearly twice as likely killed by police as white men. The United States Civil Rights Commission concluded that while people of color make up fewer than 38% of the population, they make almost 63% of unarmed people killed by the police. Anyone who has followed policing in the United States has seen the real-world examples of this. We all know names like George Floyd, Eric Garner, Walter Scott, Michael Brown, Laquan McDonald, unarmed men killed by the police, all of whom were African American. I believe what's been understudied, not looked at nearly enough, is the contribution of the Supreme Court to the problems of policing in the United States. Throughout American history, the Supreme Court has failed to enforce the provisions of the Constitution that were meant to constrain the police. Quite the contrary, what the Supreme Court has done is empower the police and thus to empower racialized policing. I intentionally chose to start the book with a specific example. It's a case that arose in Los Angeles. It might be familiar to you. It involved a 24-year-old African-American man, Adolph Lyons. He was stopped late one night by police officers for having a burnt-out taillight. The officers ordered Lyons out of the car, which the officers were allowed to do. An officer slammed Lyons' hands above his head under the roof of the car. Lyons complained that the keys that he was holding were cutting into the skin of his palm. The officer thought that Lyons was, quote, mouthing off. The officer administered a chokehold on Lyons. The officer literally put his forearm around Lyons' neck and choked until Lyons was unconscious. Lyon awoke. He had urinated and defecated. He was spitting blood and dirt. He was given a traffic ticket and allowed to go. Lyons did some research and discovered at that point 16 people in Los Angeles, almost all like him, African-American men, had died from police use of the chokehold. Lyons sued the Los Angeles Police Department for an injunction. He wanted the court to stop the police from using the chokehold, except in circumstances where it was necessary to protect the officer's life or safety. In other words, Lyons wasn't asking for a total end to the chokehold, just wanted it restricted to instances where it was necessary to protect the officer's life or safety. The United States Supreme Court, 5-4, ruled against Adolph Lyons and in favor of the city of Los Angeles. Justice Byron White wrote for the court. Justice Thurgood Marshall wrote for the dissenters. The court said that Lyons could not sue for an injunction because he could not show that it was likely that he personally be choked again in the future. The court said a plaintiff like Lyons who wants an injunction has to show a likelihood of future personal injury. Of course, this means no one will ever be able to go to court to get an injunction to stop police from using the chokehold. No person can show that it's likely that he or she will be choked in the future. I've been part of countless conversations, many lawsuits, trying to challenge police procedures that were dismissed on account of Lyons versus Los Angeles. There were a couple of cases that involved city police departments where police officers strip searched women who were stopped for routine traffic violations. The women who were subjected to this sued the police to stop the degrading, humiliating practice. But the court said these women couldn't show that they would be stopped and strip searched in the future, so they didn't have standing to be able to sue. I intentionally began the book with this example, in part because it's one that's not familiar to most non-lawyers, and in part because it shows the human consequences of the Supreme Court's decisions. If the Supreme Court had ruled in favor of Lyons, then maybe the chokehold wouldn't have been there to be used against Eric Garner or against George Floyd, who died from it. I decided to tell the story of the Supreme Court and the police chronologically, looking at how for the first century of American history, there were virtually no Supreme Court cases enforcing the constitutional provisions meant to limit the police. The Fourth Amendment limits police searches and arrests, but there were no Supreme Court cases for 100 years about the Fourth Amendment. The Fifth Amendment protects us from having to forced to incriminate ourselves, protects the privilege against self-incrimination. There were no cases about this from the Supreme Court for the first 100 years of American history. Due process protects us in many ways. It might shock you, but it wasn't until 1932 that the Supreme Court first said that the Sixth Amendment right to an attorney applied in state courts where it was a capital case, was a possible death sentence. Or I'll put it another way. For the first 141 years of American history, a state could try a person for a capital crime in state court without needing to provide that person a lawyer. And it wasn't until 1963, in the famous case of Gideon versus Wainwright, that the Supreme Court held that anytime a person faces a possible prison sentence, when they're tried in state court, Sixth Amendment requires that there be a lawyer. Or again, to put it another way, for the first 172 years of American history, a state could try someone in state court without needing to write a lawyer, even if the penalty was life in prison. I then tell the story of the Supreme Court in the early part of the 20th century, under the more liberal Warren Court, and then what happened since with the Burger courts, and subsequently in the Rehnquist and Roberts courts. I thought for this brief presentation, what I would do is focus on three areas that I discuss in the book. One is the rights that people possess. The second is the remedies that exist when there's violation of those rights. And the third is the solutions that might be adopted in light of these problems. So let me start by talking about the rights we possess. I've already alluded to some of the rights. Obviously, in a short presentation, I can only discuss some of them and give a few examples. But let me start with the Fourth Amendment. The Fourth Amendment is so important in limiting when the police can stop, arrest, or search a person. And yet what you see is that the Supreme Court has tremendously expanded the power of the police to do this. So much so I want to show you that it's not hyperbole to say that the police can stop and search virtually any person at any time. A key case here, ironically, that greatly expanded police power came from the Warren Court in 1968, Terry versus Ohio. Case arose in Cleveland. A Cleveland police officer saw a couple of men on a street corner and said they were walking back and forth. Now keep in mind, the men were on a public sidewalk. Everything they were doing was legal. They were walking back and forth up down the sidewalk. But the officer said that he thought maybe they were, quote, casing the joint. I don't think it's coincidental that the police officer was white and the two men were black. The officer then went to the men. He forced them into a store. He had them stand spread eagle. He patted them down, and he found that two of the men each had a gun. They were arrested for illegal possession of the gun. The men argued that the police officer violated the Fourth Amendment. The Fourth Amendment, in its very text, says police can search or seize someone only if they have probable cause. There's a probable cause that the person has committed a crime. There was no probable cause here. Not the state of Ohio, not the police officers said there was probable cause. But the Supreme Court ruled 8-1 that there doesn't have to be probable cause for the police to stop and frisk someone. There only has to be a lesser standard met, reasonable suspicion. Now, the court didn't define reasonable suspicion. To this day, the court hasn't defined reasonable suspicion. The court just said it's much less than what's needed for probable cause. Why did the Warren Court, the most liberal in history, decide this? The majority opinion was written by Chief Justice Earl Warren. Liberal lion William Brennan was in the majority. Thurgood Marshall, the greatest civil rights lawyer in history, was in the majority. Only Justice William Douglas dissented. I think it was a reflection of the time. 1968 was a very tense year in American history. There have been riots in many major cities. Between when the court heard oral arguments and decided Terry versus Ohio, Dr. Martin Luther King was assassinated. That led to riots in many major American cities. Also, Richard Nixon was running for president that year against the liberalism of the Warren Court. Said he would appoint law and order justices, strict constructionists. But what the Supreme Court did in Terry versus Ohio is tremendously open the door for the police to stop and frisk people. And we know that it's used in a racialized manner. Statistics from every major city, and I present them in the book, show that Black and brown individuals are far more likely to be stopped by the police, holding all their variables constant. And they're more likely to be stopped, even though it's less likely they'll be found to have contraband or weapons. Well, subsequently, the Supreme Court built on Terry versus Ohio and greatly expanded the power of the police to stop people. I think one milestone here was a case in 1996, Wren versus United States. It involved a couple of undercover District of Columbia police officers who were driving through a neighborhood. They later said it was a high crime area. That, of course, is a euphemism for a community that's predominantly individuals of color. The officer said that they saw a car stop at a stop sign an unusually long amount of time, 20 to 25 seconds. Based on this, the officers decided to follow the car. Now, in DC, undercover police officers are not allowed to enforce traffic laws. Nonetheless, these undercover officers waited until they saw the car change lanes without a turn signal. The officers then pulled the car over for that traffic infraction. The officer ordered the driver and the passenger out of the car. The officer did a search of the car where they had been and found illegal drugs. There's no doubt that this traffic stop was a pretext. The officers were using it as an excuse to pull over the car and search for drugs. But the United States Supreme Court ruled in favor of the police. In an opinion by Justice Antonin Scalia, the court said, so long as the police have probable cause or even just reasonable suspicion that a traffic law has been violated, the police can pull over the car. The actual motivations of the officer doesn't matter. Every time I teach constitutional law or criminal procedure, I hear from my students, especially the Black and Latino students in the room, of their being stopped by police officers just for driving while Black or driving while brown. When I was working on the book, a police officer told me that if he followed any driver for 15 minutes, he'd likely see a violation of a traffic law, going a mile over the speed limit, turning or changing lanes without a turn signal, not stopping long enough at the stop sign, and so on. One more example of this, case called Wardlaw versus Illinois. William Wardlaw was walking down a sidewalk in Chicago. not suspected of anything, not doing anything wrong. He saw 4 cars coming towards him in caravan fashion. He recognized them as police cars. He decided to walk in the opposite direction. Upon seeing Wardlaw change his direction, one of the officers pulled over and pulled Wardlaw over. Now, the only basis for suspicion of Wardlaw is that he chose to walk away from the police officers. I think if you're in a city like Chicago or Los Angeles, and especially if you're a young man of color, it might be sensible to walk away from the police officers. But the officer on that basis alone stops Wardlaw, frisks Wardlaw, and finds he's carrying a gun. And the Supreme Court said the stop and the frisk didn't violate the Fourth Amendment, that was enough for reasonable suspicion. Another of the examples that I talk about in the book with regard to rights concerns eyewitness identifications. Study after study has shown that innocent people get convicted in court because of faulty eyewitness identifications. Because of the work of the Innocence Project, we know of many individuals who were wrongly convicted. Frequently, they're exonerated when DNA evidence showed that they don't commit crime. We then look back and see, well, how was there the wrongful conviction? Time and again, it's because of an inaccurate eyewitness identification. There's so many reasons why eyewitness identifications are fallible. Often, the victim or the witness just gets a fleeting glimpse of the perpetrator. It's usually at a high stress situation. Also, we know that cross-racial identifications are particularly inaccurate. And yet, do you know how many cases the Supreme Court has decided from 1986, when William Rehnquist became Chief Justice, until today, about eyewitness identifications? One, about a decade ago, and it ruled in favor of the police. The Supreme Court has simply ignored the problem, completely ignored the problem of faulty eyewitness identifications. So that's some of the examples of what I talk about in the book with regard to the failure to protect rights. The second topic that I have for today concerns remedies. Rights are meaningless unless there's remedies. I used to, and this was when I was at the University of Southern California for many years, start my constitutional law classes, both for undergraduates and law students, by having them read a copy of the United States Constitution and a copy of the Stalin-era Soviet Constitution. My students were always surprised that the Stalin-era Soviet Constitution had a far more elaborate statement of rights than the United States Constitution. I'd also have them read an excerpt from Solzhenitsyn about life in the Gulag. And I would always ask them, how could this be? And of course, the answer is there were no remedies in the Soviet Union if the government violated the Constitution. We could have the most perfect statement of rights to limit the police, but if no one was there to enforce them, if there are no remedies for violation, then the rights become meaningless. And that's why I spend a good deal of the book showing how the Supreme Court has not only cut back on the rights, but even their rights is very much less than the remedies. Well, what are the remedies if police violate the Constitution? One possible remedy is called the exclusionary rule. This is the idea that if the police engage in an illegal search or gain an illegal confession, the fruits of that have to be excluded, can't be used as evidence. The hope is that this will deter police violations of the Constitution. But the Supreme Court has very much lessened the protections of the exclusionary rule. One of the most important cases was in 2009, a case called Hearing versus United States. What's involved here is a police officer was driving and he thought he recognized a driver as somebody who'd been a troublemaker in the town, and he had the license plate run. And it turns out that their records of the computer showed there was an outstanding warrant for the individual. And so the police pulled the person over on the outstanding warrant, searched him, and found evidence. Well, it turns out there was no outstanding warrant. The old warrant had been lifted a long time ago, but it was the computer system that was in error. The person who was arrested said, this was an illegal search. The evidence should be excluded. The Supreme Court 5-4 ruled in favor of the police. Chief Justice John Roberts wrote for the court. He said the exclusionary rule applies only if the police intentionally or recklessly violate the Constitution. If the police negligently or in good faith violate the Constitution, then the evidence comes in. Well, especially where it's a high-profile case, particularly where it's a serious crime, judges don't want to exclude the evidence. So it's so easy for the judge to say, oh, the police officer was just negligent in violating the Constitution. The evidence gets to come in. And I think there very well may be 5 justices on the current court to completely eliminate the exclusionary rule as a remedy. Justice Scalia argued for this when he was on the court. He was never able to get more than 4 votes. But now, with the shift in the composition of the court, there may easily be 5 or 6 votes. Well, the other remedy that exists if the police violate the Constitution is civil suits. Sue the police. Well, one thing you might want to do is sue the police for an injunction to stop them from violating the Constitution that way in the future. But as I said, City of Los Angeles versus Lyons makes it very difficult, not impossible, to sue the police for injunctive relief. Another possibility would be to sue the police for money damages. Well, the Supreme Court has made that very difficult as well. One possibility would be to sue the city or the police department that employs the officers. But in 1978, in Minnell versus Department of Social Services, the Supreme Court said a city, a government can be held liable for what its officers do only if the city policy causes the constitutional violation. So if police use excessive force, beat somebody up, you can sue the city only if you can show there was a city policy to use excessive force and beat someone up. Think of this in the context of George Floyd. The estate of George Floyd sued the city of Minneapolis, but they would have only been able to recover if they could prove that Minneapolis had a policy to use the chokehold in this way. Something almost impossible to show. Now, Minneapolis wisely chose to settle the lawsuit with the estate of George Floyd, so it never got there. But it's very difficult to hold a city liable for what the officers do. Well, the other possibility here is sue the officers, hold them liable. But here too, the Supreme Court has made it so difficult to sue the officers. The Supreme Court has said that when government officials are sued for money damages, they always have what's called immunity defense. Some government officials have absolute immunity. They can't be sued at all. Judges for their judicial tasks, prosecutors for their prosecutorial tasks, police officers when they testify as witnesses can't be sued for money damages at all. Even if a police officer commits perjury in court and an innocent person is convicted and spends years in prison, the police officer can't be sued for money damages. The police officer can be criminally prosecuted, administratively disciplined, but can't be sued for money damages. All government officials who don't have absolute immunity have qualified immunity. And I know the phrase qualified immunity has been much in the news since the death of George Floyd. Qualified immunity means that the officer can be held liable only if the officer violates, and I'm quoting, clearly established law that every reasonable officer should know. It has to be right established beyond debate. The Supreme Court has said that qualified immunity protects, quote, all but the plainly incompetent officers. In case after case, the Supreme Court has reversed lower court rulings against the police, with court ruling in favor of the police based on qualified immunity. A study was done last year by reporters at Reuters. It won the Pulitzer Prize. It documented the extent to which the lower courts are using qualified immunity to protect the police. Let me give you an example. It's a case from October of 2021 from the Supreme Court. It's City of Tahlequah, Oklahoma versus Bond. A woman called the police that her ex-husband was there and was bothering her. So the police came, and the police found the ex-husband in a garage type area, a tool shed. The officers told the man to come out. The man was standing next to tools and picked up a hammer. The officers ordered the man to put down the hammer. Now, the man wasn't in striking distance of the police. He wasn't even at a distance where he could have thrown the hammer and done it, but the officer told him put down the hammer. When he didn't immediately put down the hammer, the officers began shooting and killed the man. The man's estate sued the police, saying this was excessive force. The Federal Court of Appeals, the United States Court of Appeals for the 10th Circuit, ruled against the police officer. The 10th Circuit said this was excessive force and the officer wasn't protected by qualified immunity. The United States Supreme Court unanimously reversed and ruled in favor of the police officer, saying he was protected by qualified immunity. My point is that if you think of any of the remedies that are supposed to be there for police violation of rights, the Supreme Court has very much lessened their availability. Well, that leads to the third and final part of my remarks, solutions. I was determined in writing this book to not just identify the problem, but to outline how we might solve it. And that's the focus of the last chapter of the book. I don't think we can look to the United States Supreme Court for solutions. The reality is, a majority of the current justices don't recognize a problem of policing in the United States or a problem of racialized policing. And we're likely to have a very conservative court for a long time to come. Take the newest justice, Justice Amy Coney Barrett. She was 48 years old when she was confirmed for the court on October 26, 2020. If she remains on the court until she's 87, the age at which Justice Ginsburg died, Barrett will be a justice into the year 2059. When Barrett was confirmed, the other conservative justices were Neil Gorsuch at age 53, Brett Kavanaugh, 55, John Roberts, 65, Samuel Alito, 70, Clarence Thomas, 72. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. So it's easy to imagine 5 or 6 of these justices being together for another decade or two. So where else can we look to solve problems of police in the United States? Well, one place we should look is to state courts using state constitutions. State constitutions exist in all 50 states. The United States Supreme Court has been clear that states can use them to protect more rights than exist under the US Constitution. And some states have done this. Some states, for example, have said that in state court, a police stop is illegal under the state constitution if it's a pretext, limiting racialized stops. Some states under their state constitutions have said that eyewitness identifications are not allowed if they're suggestive, and thus try to provide more protection. And I go on with many examples, provide several in the book, but we need to look to state courts and state constitutions. Now, of course, that's realistic in California or New York or some states, but I don't know that it's going to come from the Texas Court of Criminal Appeals or come in a number of other states. Another possibility is legislative action from Congress, from state legislatures, from city councils. I signed the contract to write this book in January of 2020, and I expected I'd take a couple of years to do it. after the death of George Floyd, the end of May of 2020, my editor got in touch with me and said, how soon can you get me the manuscript? And I finished over the summer and I got it in October of 2020. When I wrote this over the summer and fall of 2020, I expected that Congress would adopt a law, such as the George Floyd Foreign Police Act, to help control policing and racialized policing in the United States. A bill was introduced in the House of Representatives that would change the standard for qualified immunity, would have outlawed chokeholds and many other things. It passed the House again this year in 2021, but it stalled in the Senate. But states can adopt laws to reform policing. California adopted a law prohibiting police from using the chokehold. California adopted a law that says police officers found to engage in certain disciplinary violations, the individual is decertified and can't be a police officer elsewhere. California adopted a law that creates a duty of police officers to intervene if another officer is violating somebody's rights. Many cities have now adopted city ordinances or police department regulations prohibiting the use of the chokehold. Another source of change is for the Justice Department to use an existing federal law. There's a federal statute, 42 United States Code, section 14141, that allows the Justice Department to sue local governments if there's a pattern in practice of civil rights violations. The Justice Department, for President Trump, used this effectively to sue cities like Baltimore, Cincinnati, Seattle, Los Angeles. I know Los Angeles best because I lived there while this was going on. The Justice Department said I was going to sue. The city settled the suit, and there's over a 100-page consent decree to reform the LAPD. A study done by the Kennedy School of Government at Harvard University found that the consent decree was enormously successful in improving police, decreasing deaths at the hands of the police, and in many other ways. But the Trump administration came in and said it wouldn't enforce existing consent decrees, it wouldn't enter any new ones. Now, with the new Attorney General, Merrick Garland, hopefully the government will use this authority. So my point in all of this is that even if the Supreme Court's not going to be the solution, there are other solutions, and they're essential. So what I've tried to do in this book is tell the story of the Supreme Court and the police. And I hope I'm able in the book to show that the Supreme Court is responsible for many of the problems that exist in the United States with regard to policing and with regard to racialized policing.
Okay, well, thank you very much. That's a very fine summary, although there are a lot of wonderful examples in the book that obviously in a short talk could not be shared. So we have a small group of concerned citizens with us. Who would like to start with a question? Okay, you need to unmute yourself, Barbara. You have to unmute yourself. You have to unmute yourself.
I hear that. Yes, I thought I had, and then it went back, and it's got its own mind in the mind in the machine. But thank you so much, Dean Chemerinsky. That was incredible. I was listening to some of your lectures and conversations about the book, and one thing you had been asked is the current Supreme Court, or even the history that you've been discussing, it sounds so political. It sounds so partisan. And yet you make the point that no, it is more ideological. And I'm not sure I see that distinction.
When we say the Supreme Court's political, we need to be clear about what we mean. In one sense, the court's not political. We can't go and lobby Supreme Court justices in the way that we can go and lobby members of Congress or the state legislature or your local city council. Justices don't trade votes in the way we expect legislators might come to trade votes. So it's not political in that sense, but it is ideological and always has been ideological. And if what you mean by political is ideological, then yes, it is political. And here, what I'm referring to is how much the decisions of the court reflect the ideology of who's on the bench. This isn't new. From the 1890s to the 1930s, there was a very conservative court that struck down 200 federal, state, and local laws, progressive laws, meant to protect workers and consumers. The first federal law to outlaw child labor got declared unconstitutional by the court in this time. The Warren Court did more to advance the rights of criminal defendants, suspects, and limit the police than any other court in history. But that's also ideological. And the current court is the most conservative court that we've had since the 1930s. And of course, those views determine the outcome. So it's just how you want to use the word political. If by political you mean ideological, then absolutely it's about ideology. Now, what's different today is that all 6 of the conservative justices were appointed by Republican presidents, and all 3 of the liberal justices were appointed by Democratic presidents. That's unique in American history. Until recently, we had liberal justices appointed by Republican presidents, John Paul Stevens and David Souter.
Right.
Conservative justices appointed by Democratic presidents, Byron White, Felix Frankfurter. But now there's such a correspondence between the ideology of the president and the ideology of the justice. Also, at this moment, because we're so ideologically polarized, presidents are picking more from the political extremes and less from the middle.
That's right.
Donald Trump got 3 vacancies to fill in his 4 years as president. To put this in context, Jimmy Carter, Bill Clinton, and Barack Obama served a total of 20 years as president, and they got to pick 4 justices among them. Carter got none, Clinton got 2, and Obama got 2. 4 in 20 years. Trump got 3 in 4 years.
Yeah.
And Trump picked 3 of the most conservative federal court of appeals judges in the country because that's how he could please his conservative political base. So that all heightens the importance of ideology on the Supreme Court.
Okay, somebody else have a question? Lee.
In any case, my question has to do with the issue or the part of your presentation as to what the alternatives are in order to get people or in order to have greater civil rights. Are there some priorities that you have? State law, the Attorney General. What are your thoughts about that?
They're not mutually exclusive. If we can do it through Congress, it's easier than doing it in 50 states. If we can do it at a state level, it's easier than doing it in cities through the state. But if Congress isn't going to act because of the Republicans filibustering in the Senate, then we have no choice but to turn to the states. And if a state isn't going to act through its legislature, then we've got to turn to cities and to police commissions. So to give you an example, I wish Congress would have adopted the law that the House passed that would have eliminated the chokehold throughout the United States. But because Congress didn't do that, I'm glad that the state of California, through its legislature, did that. In some places, the state legislatures haven't done it, but the cities have done it through their city councils and police commissions. So I think we need to use all of the tools we possibly can.
Alan, you have a question?
Yes. Well, thank you very much for speaking here. And when I hear you speak, I now remember why we miss you so much every year. But my question is actually about the lower courts rather than the Supreme Court. And, I'll call them the Federalist Society judges. Supposedly Trump got to appoint this incredible amount of judges to the lower courts that were recommended by the Federalist Society. And people, at least I do, have my doubts about how well they were vetted, if they were vetted at all in the Trump administration. But my question is, a retired federal judge can go earn a lot of money. And these people are sometimes in their 30s, sometimes in their 40s. Just based on your experience, I know I'm asking you to look into a crystal ball, But in 5 years, 10 years, 15 years, do you foresee a large exodus of these judges to cash in their chips in the private sector?
No, I don't. 1/3 of all of the lower federal court judges, the federal district court and federal appeals judges, were appointed by Donald Trump. That's an amazing statistic. In 4 years, he appointed 1/3 of all of the federal judges on the bench. And he appointed very conservative individuals, some with strong qualifications, some without strong qualifications. He appointed very young individuals. Well, I'll give you an example. He appointed a 36-year-old federal district court judge in Kentucky, Justin Walker, to be a judge on the DC Circuit. Walker, when he was appointed by Trump to the district court, was ranked by the American Bar Association as, quote, unqualified. When President Trump nonetheless appointed him to the United States Court of Appeals to the DC Circuit, the American Bar Association again ranked him unqualified. Both times he was confirmed without a single Democratic senator voting in his favor. He's going to be there a very long time. President Trump appointed the Ninth Circuit to Judge Lawrence Van Dyke. The ABA wrote the most negative letter I've ever seen it write about any nominee and ranking him unqualified, describing him as arrogant and lazy and saying other very unflattering things. He got confirmed without a single Democratic vote. They're going to be there a very long time. Might they leave to go get more lucrative positions? Oh, I'm sure that some of them will, but not that many people leave the federal bench. It's a great job. Life tenure is a good thing. And do you remember the old Simon and Garfunkel song? I'd rather be a hammer than a nail. As the judge, you're the hammer. And it's much better than being the lawyer and the nail.
Okay, thank you. Jonathan, at last, one of your biggest fans. Jonathan.
Thank you. Thank you. My question really plays off the first two. Barbara's about politics and ideology, and Lee on the book. I too really enjoyed the book a lot, but I was not the least bit surprised, given hearing you talk about cases for 9 years. It's wonderful how you tell the story in detail of a litigant before you, and then get to the legal issues involved. I'm glad you raised the state remedy. I know you've written and you're speaking for a national audience, and we need to worry about the national other states. Am I correct that we're fortunate in California to have had the Supreme Court that we have, the legislature, the governors, the appointments? My experience is that we're very fortunate in many regards, and specifically, I left John Vandekamp's DA's office before his commission, and so I didn't follow it really closely. But I understand that his commission really had some wonderful things to recommend about, for example, lineups and video interrogation and things like that. And so could you comment on whether, and of course in California, we have the wonderful Ninth Circuit, to help us out if the Supreme Court doesn't overrule them. So state remedies, state constitution, Vandekamp. Can you talk about our situation in California a bit?
Sure, let me tie your question with the prior one, starting with where you ended, the Ninth Circuit. Donald Trump picked 10 judges for the Ninth Circuit. That's more than 1/3 of the judges who are in active status in the Ninth Circuit. And he picked some really conservative individuals. So the Ninth Circuit today isn't the Ninth Circuit that it was 5 or 6 years ago. In terms of the California Supreme Court, there's certainly been times in American history where the California Supreme Court was very progressive, in fact, a leader in the country. And if you look prior to 1986, when you had Chief Justices just stars in American legal thought. In 1986, 3 of the justices got removed from office, were denied retention in a recall election. Rose Bird, Cruz Reynoso, who just passed away, and Joseph Grodin. And I think there was a time when the California Supreme Court didn't have the legal leaders, the legal brilliance that it once did. I think that one of the things that I have to commend Jerry Brown and Gavin Newsom for is the quality of some of the people they picked for the court. Though he's just resigned from the bench, Stanford professor Tino Cuellar was on the California Supreme Court. Just impeccably qualified. Goodwin Liu, who was a professor at Berkeley before going on the court. I think very highly of recent nominees such as Martin Jenkins. And I'm hopeful that the California Supreme Court will use the California Constitution to really expand rights beyond that's in the United States Constitution. Unfortunately, a lot of the proposals in the Van de Kamp report, including the ones that you mentioned, haven't yet been adopted. But the California legislature could do it. The California Supreme Court could do it under the California Constitution.
Okay. Richard, would you like to ask a question? I have to unmute.
My question would sort of be directed at a Supreme Court decision where they sort of took the Fourth Amendment and probable cause got kind of turned into reasonable suspicion. Is that kind of rewriting the Constitution?
It is. And of course, this is a place where the Fourth Amendment is explicit. It says the standard for searches or seizures is probable cause. And there was a century of decisions fleshing out and developing the law as to what's probable cause. And yet then the Supreme Court adopted a new standard for police stops and police searches through frisks, reasonable suspicion. And one would think that conservatives who so stress focusing on the text of the Constitution would recoil against this. But it's been the law ever since 1968.
Remarkable.
All right. Well, this is a tale of remarkable facts. We're almost out of time. I would like to ask a different kind of question. I believe it's my turn now to ask since everyone's asked one. And that's to bring a little international perspective. If I could ask you to wander a little beyond the scope of your book, I'm really curious about other developed countries, Canada, France, whatever, other democracies. How does the United States compare with other developed democracies in terms of the amount of latitude that it currently gives the police?
Well, one thing that's different is that in the United States, deaths from police shootings, injuries from police shootings are vastly higher than any other country in the world. So just in terms of people dying at the hands of the police, this is a place where there's no comparison to the United States and the rest of the world. But of course, we also have to put this in the context of the United States has 5% of the world's population and 25% of the world's prisoners. I don't think one can separate entirely what goes on with regard to policing from the mass incarceration that we've seen in the society in the last 40 years. Now, there are places where other societies put more controls on their police. There's places where other societies put less controls on their police. A lot depends on where we're looking at and what particular right. But the statistics comparing the United States and other countries are really stunning.
Okay, I think we probably have time for one more question if it's a short one. Jonathan? You have to unmute.
Unmuted. Thank you. Yeah, this will be short.
Brief.
In the first part of your book, you talk about the politics of support for police, for law enforcement, Nixon's campaign. In con law, when I took con law, we looked at the background of the justices, and they really correlated strongly to their decisions. If we look at the national support for the police, for the rise of victims' rights, for the lack of real appreciation of constitutional rights of defendants, do you think that accounts to some or great extent, and the backgrounds of the six most conservative current justices, does that account to some extent for their decisions on, for example, qualified immunity?
The simple answer is yes. There's no doubt that the ideology of the justices very much accounts for their views with regard to policing. We can talk about why, but conservatives have historically very much backed up the police. Liberals have wanted more reform, and we have a court that's 6-3 conservative versus liberal. But I also think you put your finger on something very important. People understandably want to feel safe. Therefore, politicians want to seem tough on crime. No politician wants to give a soundbite for the next election to an opponent that would make the individual seem soft on crime. So all of the political pressure has historically been in terms of backing up the police, not in terms of controlling or reforming the police. In terms of the ideology of the current justices, or more specifically their background, most of the justices grew up in a very privileged environment. They didn't have to deal with what minority communities have to deal with regard to policing. Sonia Sotomayor is Puerto Rican. She grew up in housing projects in New York, and she's been very eloquent in talking about what parents of color need to tell their children about the police and what policing means in those communities. But she's the only voice in this regard on the current court.
Okay, well, thank you for doing a fine job answering all our questions. I'm afraid we're out of time, so we're going to have to close our broadcast. Concerned Citizens thanks Erwin Chemerinsky for helping us to understand one of the most perplexing and disturbing questions of our time. Why do the police get away with murder? If you'd like to learn more about how America arrived at this place in history and what we can do to reverse it, read Presumed Guilty. And finally, Concerned Citizens thanks you, our audience, for joining us in this informative episode. Please join me for another provocative program next time.